As we explain to ourselves and explore the ideas of local economy, we can see how personal economics, personal government, self-government, and self-direction, and the desire for self-determination can make a man like you, my listener, overturn by yourself a bad law. You, my listener, the one no vote on a jury can block a prosecution. You, my listener, the man who is cautious, the man who is personal, and the man who believes in local economy can take a prosecution by the good people in Washington against a man there in the defendant's box and say, this law may be fine. This is a drug law. This drug law may be fine, but this man who was simply trafficking in bits of dried leaves, which are called contraband in federal statute, this man has done nothing worthy of prison. And we don't know exactly how long he'll be in prison because we're not told that as jurors. But we think that it could be 8 or 9 or 10 years since he had a couple of pounds of this very, very fine herb in his possession with the intent to resell. And he was caught at a traffic stop. The man, clearly not very smart, consented to a search of his sedan. And under the back seat was found these 2 pounds of very fine weed and remedy, legal in many states. But here now we're being asked by the good people, the man in the very fine suit, and seeming ambition, a gleam of expertise in his eye, that this is an evildoer, a malefactor, and we need to put him away. We need to teach him a lesson to make of him an example for others, that they dare not contravene a federal law that says this type of medication is illegal. Whereas we all know that the opioid crisis in our state, which is ruining in rural areas, especially hundreds and even thousands of families, is licit and regulated by the same good people who are here, accusing a private purveyor of hallucinogens, and while the good people, are allowing and licensing and taxing much worse narcotics sold in the open marketplace by state licensed doctors who went to the state medical school in Memphis and have their license to practice physicianry, doctory here in Chattanooga, and so this is what you have to think about. Now, there's a problem here in the mind of the judge, in the mind of the prosecutor, the mind of people who write books such as the one I have here in my hand, Trial Handbook for Tennessee Lawyers. I've got Robert Birch's edition. It's a few years old now, 11 years old. But a lot of these things in here don't change between editions, even after decades. Often there are just a few words changed with fresh editions of legal books that are about basic principles, basic practice. And the jury is the whole issue of your power, your secret power to overturn the law itself is not mentioned in this chapter 36, conduct of the jury. That doesn't come up. Where the jury, the whole question seems to be avoided by this very, very fine writer of legal analysis. You have a right, my listener, to overturn a wicked law. You, my listener, it's not a right, really. You, my listener, have the power. You have the authorization before God and in the Tennessee Constitution to overturn a bad law and to overturn a particular use of a good law, a just statute, here being misapplied to a hapless defendant. I think of now how bad laws work, and I have my one of my titles here of this 1,000-page volume in the Tennessee Code annotated official edition here. Bright gold embossed letters on the green cover, very heavy book. It's the 1997 replacement with a 2001 sleeve edition. And again, it's some things may have changed here, but I'm looking at, just for example, a bad law. Okay, here's a bad law. And people are charged with this. They're charged with resisting arrest. Okay, resisting. It's just called resisting. Okay, well, what does that mean exactly? How is it that this statute can be easily misapplied? I have seen cases where Neil Pinkston and his staff at the DA's office have just misapplied law horrendously. They take a law that has nothing to do with the case and throw it at the poor man in the jail over Silverdale, and he agrees to it. And they drop the other charges that are more substantial, more likely to be connected to the facts of the case. And he pleads to the worst charge of all, which is the Antonio Bell case, which is intimidation of a judge. Well, that statute is simply misapplied in the Bell case that we talked about and looked at not too long ago. Here, though, in Chapter 39, we've got this law called resisting arrest. Well, the problem is that how can you be arrested? How can you be charged with resisting arrest of yourself if there's no underlying charge? So how can an officer gather the wherewithal legally to say, I'm going to arrest that man, and then the fact that you resist is an additional charge against you? So there can't fail to be, I should say, there can't fail to be an underlying charge. It says it is an offense for a person to intentionally prevent or obstruct anyone known to the person to be a law enforcement officer, etc., from effecting a stop, frisk, halt, arrest, or search of any person, including the defendant, by using force against the law enforcement officer. Okay, so if you use any kind of force, now what is that though? Force, is that deadly force? What if you just touch the officer's shoulder and say, "Sir, I've seen this whole thing, and you are harassing this person." Here the officer is going to arrest somebody. He turns upon you now that his buddy has arrived in another car, or maybe it's the fourth car, right? We have some homeless person standing there chagrined, and you're saying, I saw the whole thing, and you tap the officer's shoulder. Well, that could be, we know what tapping police property does, right? We got that woman in Minneapolis shot dead because she perhaps tapped the hood of the car to warn the officer that she was approaching him. And he took that as an assault, and he turned and shot her dead. We know what tapping, that could be an assault. That could be interference. That could be resisting. That could be interfering with the process of the state corralling this homeless man and going to take him to the jail on some kind of charge, right? Of disorderly conduct, because the man raised his voice and shouted. That becomes disorderly conduct. Again, that statute also, the disorderly conduct statute, is unconstitutionally vague, with at least 2 of its 5 provisions being unenforceable. They're unconstitutionally vague. But guess what? The lawyers who are part of this game, they play the game, no one's appealed this case up. The only person who would appeal such a case up is an individual acting on his own capacity, because no one else has the wherewithal or the time or the money to overturn an evilly vague law. The statute goes on to say that it is and here's the part that I wrote in my margin. Really? I'll show you. If you look at me on YouTube, the right-hand page there, you see I've highlighted it in yellow. This is the part that really throws me. And again, the juror should say, what on earth is this case about? Why on earth is this case here? Because it says, and also on YouTube, by the way, we are on YouTube and Facebook. Facebook is Nooga Radio, David Tulis. And on YouTube, it's Hot News Talk Radio. The next provision says, except as provided, it is no defense to prosecution under this section that the stop, frisk, halt, arrest, or search was unlawful. So you have an unlawful stop, search, arrest, and search, and you can't avoid prosecution by the fact that it was unlawful. So how can that be? How can you be resisting something that's unlawful and now you're being charged? So you're resisting an unlawful search, frisk, and he can charge you legally under the statute with resisting. You see what I'm saying? This is an evil law. It is simply evil. It is evil. It is wicked. And Neil Pinkston and his very fine staff of attorneys down there at the DA's office, they can use it against someone in this case. Okay, this is a law that has to be overturned. Now, we know that we can't overturn it politically, right? It's impossible almost to do that. It's just impossible. We need to have more free market-oriented, constitutional-minded senators and legislators to do that. But there's no cry, there's no constituency, if you will, for change in that statute politically. So how does that law change? Well, it's changed by you, my listener here at the David Tulis Show on Nooga Radio. You are the man, and your wife. If she's called a jury, she's the woman to make this happen, or your daughter. She's of age, she's of maturity, and can give consent. She is able to be on a jury too. Or your son, all the members of your family, if they are adults, may be called to jury duty, and they should gladly accept the call. They should gladly accept it, though they may be paid an impoverishing $13 a day. You don't worry about you don't do it for the pay. You do it for the duty, right? You should be glad to be corralled, to be summoned to Hamilton County Court to do this very fine duty, or to federal court. Now, federal juries and federal grand juries, as they like to say, would indict a ham sandwich. They're so pliable in the hands of our very fine, a very, very fine prosecutorial bar there, serving the good people. But federal juries aren't as mussy as the grand juries, and sometimes they will stand up. I think the Lloyd Long tax case back in the 1980s, jurors found him not guilty of willful failure to file. That was one case that I was a witness to, and rarely enjoyed seeing the jury see that the prosecution was just a joke, kind of a joke. Now, the question is, how is it that you're free to do these things? And I hope you'll give me just a minute to think about how you can queer, you, my listener, can queer the prosecution by using what God gave you, and that is local economy. Well, what I mean to say is, He gave you a conscience, right? Your conscience is the thing that is your soul. It is the seat of your person. It is the part of you that is not just the man, right? Not just blood, bone, and spit, right? Not just your physical makeup, your biology. The soul that God gives you is enwrapped in a body, right? You're a soul enwrapped in a body. So the soul is within the person. It is his consciousness, his conscience, and his soul. The soul is the means by which God makes us human beings. We're human beings and not just animals, because we have a soul made in God's image, the whole of it, right? Not just the body, but the soul itself, the spirit, if you will. And that is the thing, the conscience that the authorities, as we'll see, the authorities give us as this power of juror nullification, the power of the juror to say, no, I void this law. This law is void. This law is irrelevant. We reject it. The beauty of this is that it's not public, right? This is all in secret. A juror works in secret with his 11 cohorts. And if he's a good man, and I would want you, my listener, to be on my jury. And in fact, I suppose that in God's good grace, I will have a jury trial at some point. And I want you, my listener, to be my juror. I want you to be on my jury. And I want you to listen very fairly and carefully. And if you all end up convicting me, well, that's fine. I have a duty in the prison, no doubt. and we'll be able to write about that. But you can't do me any wrong. You, my listener, can do me no wrong, even if you find me guilty of something. But I would want you, my listener, to be the one empowered to judge the facts and the law. The court system says generally that you have the authority only, under the law, only to judge the facts. But it's impossible to judge facts alone. In fact, it is impossible. Even though the many fine words that talk about the juror's duty to weigh facts, to exclude prejudice, exclude opinion, there are many things that are right and reasonable regarding the conduct of this juror. Should a juror read newspaper accounts of the case upon which he is going to judge? Well, probably not, right? Those are reasonable and good things. The isolation of the jury sometimes is essential, especially if there's a great interest in a particular prosecution. He shouldn't listen to news reports. He shouldn't have private contacts. He should not be seeking private information about the case. That's something that I would agree with the authorities is something that should be avoided, because in that venue, you want the purest of the material presented. The prosecutor's facts, the prosecutor's argument, and the defense's facts and the defense's argument. What are the rules? Jurors, it says in this handbook for lawyers, jurors are the sole judges of the credibility of the witnesses and the weight to be given to the testimony of each of them, taking into account their ability and opportunity to observe, memory, their manner while testifying, any interest, bias or prejudice, and the reasonableness of such testimony when it's presented in the light of all the evidence. You shouldn't be influenced by sympathy or prejudice. You, the juror, should consider the evidence, but not the law. Okay, there you go. We're told here in this one side phrase that you're not to judge the law. You're to consider the evidence in the light of your own observations, experiences in the affairs of life, and common sense. Okay, those are all good things. But notice that this lawyer is telling you that you can't judge the law. Well, he's simply wrong. It's just simply wrong. The jury must consider only the facts in evidence, and the personal knowledge as to the facts on the part of a juror should not be injected into the deliberations. And I would not have you dispute that. Okay. He says also the democratic process of conducting meetings is much part of the American framework. So a jury is very democratic, right? And it is the jury's job is deliberative, it is democratic, and it is at the roots, right? Here, the roots are judging behind the mighty. The great ones in Nashville, the mighty ones in Congress are Attorney Fleischman's, our Bob Corker's, and our Lamar Alexander's. They are the mighty ones who write these laws, often with, they don't even read them sometimes, and push them out, not thinking of the consequences. And here now an evil consequence has come to be. And what are you, the juror, to be doing? You are to judge the entire thing. You judge the law. And so what happens is, because you have a conscience made in God's image, and you have a basic sense of right and wrong. We know that rape is wrong. We know that murder is wrong. We know that fornication is wrong. We know that adultery is wrong. There are many things we know, because we're made in God's image, are simply wrong. Now, we can hide the effects of that guilty conscience. We can cover it over. We can smother it with cologne, the cologne of rationalizations. We can make them smell fine, but we know certain things are wrong. We know that a police beating a Hispanic man who can't answer his questions, we know that that's wrong in Red Bank. We know that that's wrong, and so we don't have to be too careful about the judge's instructions about judging the facts. Because we have consciences, we judge the whole. It is a whole thing that you judge, no matter how many pages in a law book there might be explaining the duties, and of course in this instance overlooking this true right. Well, this is David Tulis. I'm just getting started. You're going to be called to jury duty, and I think you need to hear how you can queer the good people. You can simply queer them up by not counting some things that they say in their prosecution as having any weight at all, and weighing greatly the defense, even if the defense is feeble, even if the court-appointed attorney has not prepared his job, has misstated things. You can tell he hasn't had the time to deal with this case. And yet here's the jury trial, and here your PD, your public defender, is just slopping it away. You can use that man's bad work and make it righteous. Right? You can make it effective in defending a defendant. But the whole PD and prosecutorial system is a state system. In the end, PDs don't go to trial. They agree. They take their ignorant charges, those given over to them to defend, and try to convince them to a plea bargain. That's all they've become, is a plea bargain meal, I'm afraid to say. John Adams said, "It is not only the juror's right, but his duty to find the verdict according to his own best understanding, judgment, and conscience, though in direct opposition to the direction of the court." Hear that? And there was John Jay, the first Chief Justice of the High Court, said, "You have nevertheless a right to take upon yourselves to judge of both, and to determine the law as well as the fact in controversy. Both objects are lawfully within your power of decision." So you see, these are noted legal minds. Thomas Jefferson, the great states' rights man, the great decentralist, the great federalist, the anti-federalist, we could say, he said, "To consider judges as the ultimate arbiters of all constitutional questions is a very dangerous doctrine." Indeed, and one which would place us under the despotism of an oligarchy. And there's a great quote from a pro-constitutional writer named Theophilus Parsons, and he said that if we have jurors, we can resist despotism. The people themselves have it in their power effectually to resist usurpation without being driven to an appeal to arms. An act of usurpation is not obligatory. It is not law, and any man may be justified in his resistance. Let him be considered as a criminal by the general government, yet only his own fellow citizens can convict him. They are his jury. And if they pronounce him innocent, not all the powers of Congress can hurt him And innocent, they certainly will pronounce him if the supposed law he resisted was an act of usurpation. And that is, I think, valuable to consider. What is usurpation? Usurpation is the alienation of a right by a false claim of authority. And we have that all the time today in our day. It is a ubiquitous process. You, my listeners, should be glad to be part of the jury, and you should count it high honor. And I would say count it as God's providence. You consider God as the providence. Consider it in God's providence. You've been called to serve on the Hamilton County jury or the federal. This is David Tulis, Nooga Radio.
The Tennessee Valley's news, talk, and sports leader, Nooga Radio, AM 1240 and